Well, welcome everybody. A meeting today to have a look at the issue of assisted dying. And it is an issue that is of increasing concern in modern political debate in the Western world, but particularly in the United Kingdom at the present time. The Isle of Man has recently passed legislation that will introduce assisted dying with a number of significant constraints. And that was introduced only within the last few days. Experts argue that Scotland and Jersey may well follow the Isle of Man lead. Passing in at the moment, I think it's in committee stage, is for England and Wales is a similar bill, a private members bill on this. So we have a number of experts here that will hopefully help you develop and shape your views on this issue. What I'm going to do first is introduce the speakers, and then we will there'll be a break. And then at the end of it all, of the speakers, we'll have a question and answer session. And I have a number of questions here that hopefully will help illuminate some of these issues. So, first is Iain Brassington, who is a professor teaching medical ethics and philosophy of law at the Department of Law at Manchester. He is a philosopher by training and has published on ethical issues related to assisted dying for most of his career. Other research interests include the ethics of genetic technologies and the proper scope of genetic privacy rights. And he also has a sideline arguing against there being any such thing as rights of testamentary inheritance. Alexandra Mullock is senior lecturer in medical law at the University of Manchester. Alex is the co-director of the Centre for Social Ethics and Policy, and her research interests include end-of-life law and ethics, reproductive law and ethics, and the role of the criminal law in relation to harmful medical misconduct. Alex has undertaken policy and engagement work on assisted dying, supporting the government of Jersey and Nuffield Bioethics Council citizens' juries, co-authoring the ethical review of the proposed Jersey law in 2023, and giving oral evidence to the Health and Social Care Committee on the assisted dying and the Committee on the Terminally Ill Adults End-of-Life Bill of 2024-5. And Nancy Preston is Professor of Supportive and Palliative Care and co-director of the International Observatory on End-of-Life Care in the Faculty of Health and Medicine at Lancaster University. Nancy is a world-leading researcher on the impact of assisted dying on families and healthcare workers through international research. She gave evidence to both the Health and Social Care Committees on assisted dying for the British and Irish governments and the Terminally Ill Adults Committee stage. She is co-chair of the European Association of Palliative Care's Task Force on the role of palliative care professionals in supporting patients and families seeking or accessing assisted dying. And I am Kevin Harrison, the least distinguished member of the panel, and my background is essentially in education, mainly politics and history in further and higher education. My interest in this is the issue of a concerned citizen. Like most people in this country, I am in favour of assisted dying, especially as a way of avoiding undue pain and suffering to loved ones and myself. Perhaps at some point in the future. But see the issue as surrounded by moral, legal and political issues that need to be thoroughly examined before action is taken. So I'm going to start with a little bit of an introduction, very general, before we go on to the meat of this afternoon's meal, so to speak. Well, a friend of mine's mother, in her last illness and dying of cancer some years ago, was in great distress. And she declared to her daughter, I wish I was a dog. An animal in such distress as I am will be put out of its misery. And I was minded of this when the recent political debate over the proposed assisted dying bill began. Indeed, many of us state similar sentiments when talking on this issue to family and friends. Usually one needs to remind oneself at a time of good health and not suffering pain on the potential of this. Would we still hold the same views when we are actually in a end-of-life situation? Would we find life, however painful, as too precious to give up. Thus, for example, one gentleman in suffering from a terminal illness, being interviewed in a recent news item, pointed out that he changed his mind from wanting assisted suicide, assisted dying early in his illness, to being against it now that the illness has advanced still further along its progress. So one may reflect that this issue has changed in recent decades as social, moral and religious values have changed, not least the growing strength of individualism as an ideology. Why should a person not be able to decide the time of one's own demise? And as always with such social issues, the answer to this question is a complex one, and it reflects society and its values, religious, political, legal, and so on. Now, history certainly gives examples of societies where suicide is an acceptable way of ending one's life, often assisted by others. But it isn't a simple answer. In ancient Rome, for example, there was no stigma at all attached to suicide. It was, I think it was Seneca who argued that life was like a feast, and one might reasonably decide when one can push one chair back, stand up, and leave the table. And indeed, in certainly elite Roman culture, ending one's own life at a time of one's choosing was a perfectly honourable thing to do. So, for example, one hostage taken to try and influence decisions of Julius Caesar killed himself in order that those influences on his leader would not take place. Others, defeat in war, committed suicide. Brutus and Cassius, assassins of Caesar, are examples of that. Similarly, Mark Antony and Cleopatra. And also, Roman emperors would order people to commit suicide when they, rather than to be killed by the emperor. This was a means by which their families could also then protect their property. So the Seneca, who we've already mentioned, and Lucan, his nephew, and others were ordered to end their own lives after having been implicated in a plot to kill the Emperor Nero. And in one sense, it was assisted dying. They would be surrounded by their family, their friends, and trying to state famous last words as their life ebbed away. Now, this began to change dramatically with the spread of Christianity. And indeed, the fundamental issue here is that life is a gift from God, and only God could take life, aside of sanctioned, religiously sanctioned situations such as criminal punishment and warfare. And as a result, there was a massive stigma attached to suicide, whether assisted or not. A suicide could not be buried in consecrated ground. Suicides in some countries were buried at crossroads with a stake through their heart to stop their spirits walking. In England at one time, attempted suicide was itself a capital offence, which is one of those strange ironies of history and law. And so, in one sense, one may assume that in the past, suicide and assisted dying would be unrepresented in the figures. Partly because relatives would try and cover it up, but also coroners would be reluctant to bring a verdict of suicide at inquests. And indeed, helping someone to end their life was a criminal offence, which led to some well-publicised cases of family members who have helped a loved one to die being forced to undergo extra stress of a trial. And interestingly, these days, the verdict rarely involves the prison sentence, but such cases may have grown in recent decades, along with increased lifespan and more people living long enough to suffer long, painful, and terminal illness. And law here often clashes with moral views and popular opinion of ending suffering and helping people carry out a right to do with their own life as they will, especially to avoid suffering. It also reflects the decline, perhaps, of formal Christianity as a belief system in modern Western societies, particularly countries like Britain. Practicing Christians, it can be argued, can choose to adhere to the principle of God-given life, but we're in a society where a majority of people polled now take a view of the importance of individual choice in avoiding suffering. Indeed, this has often been identified by social science researchers as being a reflection of society and its values, perhaps the most famous of which is that of Emil Durkheim back at the end of the 19th century, where he saw a quite close correlation between Protestant countries, which tended to have higher suicide rates, than Catholic countries, which tended to have lower suicide rates. And indeed, that these issues are related very closely to individuals' values as part of a general values in society. Indeed, other cultures such as Japan, suicide was often the means of ending a life that had been tainted by dishonor. So, as we see, the concepts of honor, the protection of others, a reasoned and rational response to a situation where there is ultimately no way out of, say, a terminal illness apart from extending pain, or even for that matter, grey areas. A soldier who takes military action and gets killed defending his colleagues. How many heroes are, in other circumstances, people who in one maybe seen as being involved in a suicidal activity? And it's not one other element. Well, it's not just individual choice, many would argue. After all, the individual is part of a wider society of friends, of family, of colleagues. They're part of a social web of people that create a society. It also related to law and is defined and constrained by law. And law, to varying degrees, reflects the social, religious, and moral values of people. Now, suicide of the sort I've just been talking about is not automatically the same as assisted dying. Indeed, Kim Ledbetter has argued that one should make a clear distinction between these two. In Canada, for example, it's called medical assistance in dying, and this is generally related to the idea of people making choices, adult, rational people, about when to end their lives, or when, with help from others in some circumstances, to end their lives, without criminal penalties to those who help a friend or a family to leave this life at a point of their own choosing, in order to avoid undue pain, discomfort, or being a burden to others, or losing their own dignity towards the end of their life. And indeed, countries like Canada are identified. I think they've had assisted dying since 2016, if I remember correctly, where in the first year about 1,000 people opted for medical assistance in dying, as it's called in Canada. By 2023, this was over 15,000 people in Canada. Around 4.3% of all deaths in Canada were some form of assisted dying. Indeed, interestingly, in Quebec, it was in 2023, 7.6% of people in Quebec, deaths in Quebec, who were assisted dying. Indeed, support in Quebec is significantly higher for assisted suicide, at 86% in one recent poll, than Canada at large, where it's running at 75%. So, and that has been widened in recent years, and this is an issue that certainly our speakers will make an address to. Certainly, if you look at the United Kingdom, there are significant majorities in opinion polls that favour reform to the law to allow assisted dying. It remains illegal to assist a suicide. Courts, though, as I say, often recognise particular circumstances and leniency towards some individuals. Often a spouse ending the life of a loved one rather than watching them suffer at the request of that loved one as well. One recent study calculated that roughly one person a week travels from the United Kingdom to Switzerland, where assisted dying has been legal for now 80 years. But that is expensive, and people often face police investigations on their return. But also, quite worryingly, 600 people a year commit suicide to avoid incriminating loved ones in their end. often starving themselves to death or denying access to water as well. This is a significant toll of misery that could be reduced. And we're now in a process related to the Terminally Ill Adults End of Life Bill that may form a basis for change in the law, introduced by Kim Ledbetter, MP. It is a cross-party issue, as we will see, where you find Labour, Conservative, Liberals, Brexiteers, Remainers forming alliances on pro and anti stances on the bill, making a huge number of amendments to it as it goes through its process. And so that will, for England and Wales, form the core of any likely change to the legislation on this issue. And so I think without further ado, let us press on to the people who know a great deal more about these issues to hear their contribution to this. So I will start, if possible, with Iain on this issue and his views on it.
Okay, thanks. Right, so I'm going to I will talk about the ethical arguments underneath the law rather than any particular substantive legal claims, because that's Alex's area of expertise. And you've already raised implicitly quite a lot of the stuff that I was going to mention. I think it's important, as we get started, about being clear, always when we're talking about the morals of any particular action, then it's important to get clear about precisely what's being talked about. So we can draw a distinction, as you indicated, between assisted suicide on one hand, and that's one kind of assisted dying, and euthanasia on the other. So the Leadbeater bill that's currently before Parliament, or the Lord Falconer's bill that was introduced in August, but is now, I suspect, pretty much defunct, they all have to do with assisted suicide and one person being allowed to assist in another person's self-killing. So that's one kind of assisted dying, but euthanasia would be entirely different. That would not be covered by any of the legislation being considered in the UK or the territories around the UK. So when we're talking about things like the Leadbeater Act, we're talking about what amounts to an alteration of the Suicide Act. Essentially, it's a matter of giving a person a defence against a charge of assisting in another person's suicide. Actually killing another person is still off the agenda, and no one is really talking about euthanasia within a legislative context in the UK. Okay, so with that proviso made, there's likely to be two related but distinct families of questions when we're talking about assisted dying, or when we talk about whether assisted dying should be permitted or legalised. And one has to do with the permissibility of Alice is helping Bob to kill himself, and the other has to do with the permissibility of Charlie killing Diane. And they're qualitatively different kind of things. So in respect of assisted suicide, where Alice is helping Bob to kill himself, then it's tempting to say that, as you indicated, well, people have the rights to control their own lives. People could end their own lives if they see fit. Therefore, it follows that assistance should be permitted. But that doesn't actually quite follow, because whatever we want to say about the permissibility of killing oneself, when we're talking about assisted suicide, there's another person involved, and so the arguments are going to be slightly different. Likewise, if we're talking about euthanasia, where this is one person actually killing another person, nothing that we say about assisted dying will necessarily commit us to anything about euthanasia. We could hold that one is permissible and that the other isn't. So I believe, and I'm not an expert on Belgian law, I'm about to get into terrible hot water here, but I believe that in Belgium, they legalised euthanasia without legalising assisted dying. And the rationale there is essentially that they've got a good Samaritan law that says that if you see someone about to end their own lives, then you have an obligation to intervene to support them. But that's obviously inconsistent with having assisted suicide. So you can kill someone, but you can't help them kill themselves in Belgium. And there are arguments in terms of whether that makes much sense, but again, we'll just park that and leave listeners to make up their own minds about that. That said, although there are these different sets of questions, they are related, and many of the same concerns are raised. You indicated in your introduction that a lot of what's going on has to do with something like respect for autonomy, a person's control over their own life and how it unfolds and how it ends. So the thought here is going to be along the lines that if people are sovereign over their own lives, then this implies that they have a right to control what happens in their lives, and again, a further implication of that is that they have the right to control what happens and the way that life ends. If people are sovereign over their own lives, then they are sovereign over their own deaths, and that's the kind of standard argument that works. And again, if you look at the way that assisted dying legislation has been introduced in the UK, that's the sort of rationale. If you look at the parliamentary debates, a couple of them over the last few months, that's the sort of rationale that's the main bell that's been rung. Now, again, I don't think that argument quite works, and there's a number of questions that we might want to ask about it. So, on a deep conceptual level, we might wonder whether it's true that people are really sovereign over their own lives, or if sovereignty is the right kind of sovereignty in this kind of context. So what does it mean to say that people are self-sovereign? You might want to say, for example, that even if people do have substantially great control, or even if people ought to be recognized as having substantially great control over their own lives, nevertheless, we can't recognize people as kind of atomic units completely isolated from everyone else. That we might want to say that we are part of a community, that everyone is bound together, and therefore individual claims or claims about individual rights that sort of take for granted a sort of purely sovereign individual simply misunderstand what it is to be human. So all the rights claims that we might want to make may become a bit too easily. But even if you don't want to go that far, even if you're not that kind of communitarian, then we still can't leap easily from claims about sovereignty over your own life to claims about how the law should deal with assisted dying. And the reason for that is fairly straightforwardly that I think all the autonomy arguments are easy to overplay. We ought to be wary of overplaying them. And the thought here runs along these lines, which let's suppose that we're satisfied that a person does have rights to control their own death, or a prima facie reason to control their own death. That might tell us something about the moral permissibility of their own ending it. And again, that's going to be reflected in questions about the legal permissibility of suicide or attempted suicide. And you mentioned that the Suicide Act, which decriminalised attempts to end your own life in the early 60s. So that's fine, and that's great as far as it goes. But assisted suicide is something different. That involves another person. So we can perhaps say that, of course, the law should not be criminalising suicide for all kinds of reasons. But that doesn't mean that we think that suicide is a good idea. And it's perfectly coherent to have a decriminalisation of suicide without wanting to decriminalise assistance, because we still might want to say that suicide is bad, and helping other people to commit suicide is, for that reason, something that the law ought to be involved with. And it's crucial when it comes to using the autonomy argument to assisted dying, or in support of assisted dying, to remember that the whole point of assisted dying is that it is assisted, right? So it means that other people are involved. And so, to that extent, the role of autonomy, I think, is likely to be slightly diluted. And it's obviously going to be important, or autonomy is going to be important in as much as that no one should be able to kill me or assist in my death without my say-so. So it's important that my autonomy be preserved in that sense. But it doesn't follow from that my autonomy gives anyone a warrant to assist in my death. It's not at all obvious to me that my autonomous choice is going to show that anyone else may be involved in my death. This does raise some problems, though. So if cases like Tony Nicholson, Tony Nicholson was in the news a few years ago because he'd been left quadriplegic after a massive stroke. He decided that his life was no longer worth living, that he wanted assistance to end that life. But granted the nature of his disability, all he could do under the law as it stood was to refuse nutrition and hydration. And the argument there is that seems terribly inhumane, that essentially we are forcing people to if they want to die, we're forcing them into an unpleasant death that they would otherwise have rejected, simply because the only way that they can end their own is this particularly unpleasant way, and that seems kind of inhumane. On the other hand, we may want to bite this bullet. We may want to say, look, there is a moral Rubicon here whereby we simply do not help other people to die. And if they misfortune is such that they cannot die without, or cannot die in a comfortable way without our assistance, then that we can admit that that's a bad thing. It doesn't necessarily follow that the law has to change, because maybe the law, for other reasons, ought to tolerate these particular anomalous outcomes. Maybe then the argument has less, or if we want to talk about legalization of assistance, we ought to be talking less about autonomy and rights to end one's own life and rights to have other people involved in ending one's own life as a more straightforward welfare claim. So the thought is going to be here that if your life is a burden to you, or if Smith's life is a burden to Smith, or Jones' life is a burden to Jones, and if we think that if a person thinks that it'd be better that he no longer live that life, then we've got a reason to help, not because of any claims about autonomy, although autonomy would be a condition, a necessary condition for permissibility, but the moral force would be carried by welfare claims. So someone is suffering, therefore we've got a reason to intervene, and that's going to help us with the Nicholinson problem. It's going to help us to say, well, look, he's suffering from his predicament, and suffering is bad, therefore we've got a reason to intervene. So the weight of the argument there is going to be carried by the goodness of relieving someone of their misery. But then there's still counter arguments to that. So in one counter argument is to say, well, that's fine, but that's not an argument for assisted dying. That's an argument for removing a person's suffering. And if there are ways to remove suffering without killing them, or without bringing about their death, then we ought to go for that. So one possibility would be a technique called continuous deep sedation. And this, in essence, is a situation in which we put someone into a coma that lasts for the rest of their natural life. And if we think there's something special about human life, and if we think there's something morally problematic about killing another human being, and that doesn't seem like so wild a claim to make, a lot of people do have that intuition. So if we think that killing people is bad, then this gives us a way to end their suffering without actually having to cross the line of killing them. We can mean that the suffering goes away and goes away forever. But they are still alive. It is potentially irreversible. So we could imagine a situation in which we have some medical breakthrough. We think we can repair whatever has gone wrong in their life. So we could potentially bring them round and ask them if they would be if they would go for the medical treatment. All this kind of stuff about about finality and avoiding the finality of death. On the other hand, I suppose the counter argument is that there's a dignity claim here. So if you might think, well, this is going to make the suffering go away physiologically, but there's a harm to be had in my simply being attached to a machine for an indefinitely long period, right? So, and that might be deemed to be sufficiently corrosive of welfare, not in a physical sense, but in a kind of intellectual or existential sense, if you like. And that itself would be something that we would want to avoid. The other aspect of what appeals to welfare, again, you touched on this in your introduction, has to do with appeals, the kind of stereotype, well, you wouldn't let a dog live like this kind of thing. So again, there's something, again, quite intuitively powerful that if ending suffering is bad, that's why we think that euthanasia is permissible in respect of pets. We tend to love our pets in something that is appreciably like the way that we love our family. So why can't we use the same kind of argument here? I guess the response to that is going to be, well, okay, fair enough. You wouldn't let a dog live like that, but isn't there something special about human life? And importantly, if we are taking our dog to the vet for the final time, it doesn't get a choice in the matter, and so the analogy doesn't quite work unless you're willing to entertain a situation in which we decide on Aunt Mabel's behalf that she's had quite enough of this, thank you very much. And that doesn't seem to be like, that's a slightly strange position to find ourselves in. And that would bring us back to autonomy claims, the idea that, well, okay, maybe Aunt Mabel has a veto on this kind of stuff. The other problem when we're making appeals to autonomy is that we would want to make sure that any request for assistance in dying is genuine. And there might be worries about how we can make sure of that, how we can be absolutely certain that a person genuinely does want to die. Might the circumstances in which we find themselves make a difference? So, for example, might it be the case that the availability of palliative care is going to make a difference to how powerful the draw of assistance in dying is? If a person is aware that palliative care is available and is accessible, then they might not be quite so keen on assisted dying as they thought they were. So the thought here is that maybe assisted dying is the least bad option rather than something that they positively want. And if that's the case, and if ending human lives is a bad thing, then the proper response to suffering might be to ensure that palliation is there rather than that we're assisting in their dying. And this is, although I'm generally fairly sympathetic to the argument in favour of assisted dying, this is a big concern that I have with the Leadbeater Bill, which is that the way it's been framed, it allows medical staff to raise the possibility of assisted dying. And that seems to me to be deeply problematic, because implicitly we could imagine a situation, effectively, I'm caricaturing slightly, but in which a doctor says, well, we could do A or we could do B, or have you thought about ending your life? And implicitly, that's the doctor saying to potentially quite vulnerable people that, well, you know what, from my expert position, your life is no longer worth living. In other words, we're going to be coerced into accepting something that they wouldn't otherwise be had. So again, like I said, I'm caricaturing a little bit, but that worry that the idea comes from outside of the patient or comes from a third party is going to alter the situation in which the decision is being made, and it may not be altering it to the good. Final thought here is that all the assisted dying laws that are being considered in the UK have been limited to terminal illness cases, and generally speaking, around the world, a lot of so in Oregon and California, it's all to do with terminal illness cases. One question might be to do with why that should be. So if we go back to something like the Nicholson case, so he'd had this stroke, he was locked in, but he wasn't terminally ill. Assuming that he was still fed and watered, then he was potentially going to live for an indefinitely long time. So there might be questions to raise about whether terminal illness really is a necessary criterion for candidacy for assisted dying. Why not widen the candidacy? But if we're going to widen the candidacy, then the question might be, well, how far are we going to widen it? What would we allow candidacy for the sake of disability, for the sake of chronic illness? What about mental illness? Is that the kind of thing where we would consider someone for assisted dying? So it's one thing to say, well, look, if you're severely disabled and you find your life intolerable, then that may give us a reason. But imagine that you go through phases of florid psychosis, and during one of your lucid phases, you decide that this is just not a game that you want to play anymore. Would that be sufficient? Would that count as grounds for assisted dying? And then you can kind of get to potentially slightly absurd outcomes, such as severe toothache. Is that the kind of thing that would warrant assisted dying? And if we're taking a strong autonomy line and saying that people are sovereign over their own lives and over their own deaths, then it's not obvious why we would want to, if someone's faced with the prospect of yet another root canal operation, why they would not just say nuts to this. And that seems crazy. So how do you draw the line between this kind of candidacy that we're going to permit and the kind of candidacy that we're not going to permit? What about Weltschmerz? What about world weariness? People who just kind of say, well, I've had enough. Is this the kind of thing that would allow for candidacy for assisted dying? So there's all these open questions, and I'm trying to stay agnostic and neutral about all this kind of stuff. But if we are going to have an assisted dying law, it's got to draw lines somewhere. So there is always going to be a question about whether we've drawn those lines in the right place. And I think that's probably quite enough from me.
Well, thank you, Iain. That was some amazing and fascinating.
I did go on a bit, didn't I?
No. On the contrary, it raised all sorts of things I'd not even remotely began to think about on this, and where particularly the issues of where you draw the line. Speaking of someone with a minor case of toothache at the moment, I'm not sure I'd wanted that to be an issue. But all the idea of world weariness, it's an interesting one that there, or minor or illnesses like the Nicholson case, or situation on the Nicholson case, where he's not terminal, but he's had enough.
Yeah.
And who decides, whether the life is worth living? And of course, I'm glad you raised the issue, which we'll discuss, no doubt, at greater length at the end. The idea how the famous slippery slope argument, how it slides into euthanasia, where in that chilling phrase of the bad guys from the 30s, certain groups where were life unworthy of life. And who decides that? Do you want to give anybody that sort of power? Except, of course, as you mentioned, with modern technology and drugs, you've already given people that sort of power to some degree, called doctors. Anyway, enough on that. That was excellent. Alex, over to you. I think you're in two parts with a break in the middle. So you choose the point, and then we'll have a short break.
Okay.
So over to you.
Thank you. Thank you to you both for your fascinating talks. So I'm going to talk a little bit about the Terminally Ill Adults End of Life Bill, which I think everyone must have heard about unless you've been living in, an isolated community over the last year or so. So I'm going to talk, first of all, a little bit about the background and a series of bills which have been presented, mainly in the House of Lords over the last few years, which have sought to legalise assisted dying. And by assisted dying, what they actually mean is medical assistance in suicide. And then I'm going to talk about specifically the Kim Leadbeater Private Members Bill. Then I'm going to look at who'll be eligible and about assessing the eligibility and who decides who might be able to access lawful assisted dying, and those arrangements and the crucial role of the two doctors. Before I'll talk briefly about the legal authorization that this law would require, and then the final act of potentially helping somebody to self-ingest the fatal medication. So over the past, particularly 3 decades, there have been a series of bills which have attempted to make assisted dying lawful. In fact, though, this goes back much further, and we can see early attempts going back to the 1930s. And so this is not a new issue. For many years, a very keen campaign group have been attempting to change the law. But attempts have really intensified over recent years. So going back to the 90s and the noughties, a member of the House of Lords, Lord Joffe, attempted to first of all make either assisting a suicide or euthanasia lawful. Then we've had several attempts brought by Lord Falconer, Charlie Falconer, who was previously a member of the Labour government. And then more recently, Baroness Meacher attempted to change the law. And then the most recent attempt in the House of Lords was brought by Lord Falconer. Iain mentioned this, and I understand that bill was withdrawn from the House of Lords when Kim Leadbeater introduced her bill into the House of Commons. In the House of Commons in 2015, there was a private members bill introduced by Rob Maris MP, and this bill was defeated by a significant majority at the second reading. And then bringing us up to date, in autumn last year, Kim Leadbeater MP introduced her bill. It's interesting that the name of the bill has been adapted. So previously, the most recent bills were called the Assisted Dying Bill, but Kim Leadbeater has called her bill the Terminally Ill Adults End of Life Bill. I guess in an attempt to be a bit more specific about the types of people who would be eligible, and limiting it to only the terminally ill, because as you may be aware, one of the most sort of prominent groups who are opposed to legalization are people living with disability, and the fear that lawful assisted dying would expand and have a very detrimental effect on those communities has been a key reason why many people do oppose a change in the law. So who would be eligible under the Terminally Ill Adults Bill? It's limited to adults who have mental capacity and who are terminally ill from a somatic or physical disease that's not treatable in terms of allowing them to have a cure for the disease, and is also expected to prove fatal within 6 months or less. So not included in the Leadbeater Bill is anyone under the age of 18, or a person suffering from a non-terminal condition, or anyone who is deemed to lack mental capacity, or deemed to have been coerced or pressured to seek help to die. So in that sense, it's quite a restrictive approach. It's quite interesting to compare it to other jurisdictions that have made the choice to make assisted dying legal. And the Leadbeater approach, when compared to those other approaches in different countries, is more restrictive than many. It aligns with an approach that's been happening for many years in the US state of Oregon and some other US states, and also more recent jurisdictions that have changed the law, such as Victoria in Australia, or indeed New Zealand. So just to have a look at the process that the bill outlines, it's a fairly lengthy process with quite a bit of bureaucracy. So I've kind of simplified it because it's an extremely long piece of potential legislation, but it begins with an initial discussion where a person raises that the issue that they would like to have help to die to presumably a doctor. If that doctor isn't in a position to help them, either because they're unable or unwilling, then they will need to refuse and put the person in touch with a doctor who is willing. And then this will be a formal first declaration of a request to have help to die. And this needs to be made to a coordinating doctor. And that's the most important doctor in this process, really, because they oversee the process. And they also assess the patient, and they have to make a formal statement before a period of reflection of 7 days, where the person is supposed to reflect on their wishes and reconsider before, if they decide to continue, there'll be a second doctor involved in the process who will also assess them. And then if they are happy that the person should be permitted to go forward, they will have a formal declaration or report saying that. The next stage is then legal authorization. So this is prospective legal authorization. In the first draft of the Leadbeater Bill, the plan was to have the High Court do this, but since then that has been removed, and it looks now, although we don't have, a very clear sense of which amendments have been agreed, it looks that the approach is going to involve a multidisciplinary panel or tribunal. If the tribunal or panel then agree that the person ought to be helped, there will then be a second period of reflection of 14 days, which is then followed, if the patient or person still wants to have the assisted death, by a second declaration where the coordinating doctor and another person who's an independent witness make a formal statement saying that the person should get the help that they want. And then finally, there will be the provision of assistance where the doctor or the registered medical practitioner will get the approved substance, which is obviously the fatal drugs, and then support the patient to end their own life. So it's quite a long process. So looking at those, the very important role of the doctors involved in this process, the bill outlines that in the initial discussions with the person who wants to die, the doctor has no obligation to raise the possibility of assisted dying, but they are free to do so without being asked. And Iain pointed out that this is a potentially concerning aspect of the bill, because there's an argument that if your doctor raises a possible option for you, that you might see that as a recommendation or a suggestion. Or even if, you take it as it is, which is one of, several possible options, It might make a patient worried that the doctor fears for them that their natural death, even with palliative care, will be very, very unpleasant. And so that might make the patient feel more afraid, and they're more likely to want to have an assisted death. If the doctor is unwilling or unable when asked for help to die, then under the Leadbeater Bill, there is an obligation to refer the person to another doctor who they would be willing to help. And this has been flagged by some as very problematic, because the whole concept of referral within the medical profession has a clear meaning, which might have an unfortunate effect of making the doctor feel that they are complicit, whereas in fact they have a religious or a moral objection to facilitating assisted dying. It looks in reality more common that a distinct assisted dying service will be established. And in that case, then willing doctors will effectively opt in to the service by becoming involved. So I think in actual fact, these problems about doctors who might be unwilling or unable to help will be dealt with by establishing a service. So looking at the doctor's assessment, the two doctors involved both must assess the patient's health and be sure that they are terminally ill of a condition that's expected to kill them within 6 months, and also that they have mental capacity. And then the last thing that they need to be sure of is that the person is acting from their own motivations, and they haven't been coerced or pressured by another to seek assisted dying. So that's some very difficult questions that the two doctors have to be sure of before they make the statement or the report agreeing that the person should be given the help to die. The next stage then would be the prospective legal authorization, and this is a very unusual approach. The vast majority of places all around the world that allow assisted dying do not require prospective legal authorization. I think there are 2 exceptions, and Spain is the most relevant because they have a sort of panel approach where a doctor and a lawyer have to agree that the necessary steps have been complied with. So this approach was initially to have a High Court judge authorise the permission to assist someone to die, but this has since been dropped in the committee stage, and now it seems to be that a multidisciplinary panel with oversight by an assisted dying commissioner, who will be a High Court judge or a judge of the Court of Appeal or Supreme Court, they will oversee the application and say yes or no. If they say no, there will be a right to appeal to the Commissioner or to the High Court. So the next step, if both doctors have agreed and the multidisciplinary panel or tribunal have agreed, is to provide the person with help to self-ingest fatal drugs. So the coordinating doctor must have control of the drugs at all times, which is a safeguard that's not present in all jurisdictions allowing assisted suicide. So, for example, in Oregon, it's not necessary for the patient to have supervision necessarily in self-ingesting, and this has been flagged as a danger. So the Leadbeater Bill proposes that the doctor would supervise the approved substance, prepare the substance, and if necessary, a device to enable self-administration. So, for example, if somebody had a condition which prevented them from physically self-administering a condition such as advanced motor neuron disease, then a device could be prepared, and the doctor would help the patient with a supported approach to doing the final step, which then led to the administration of the substance. And that might come perilously close in many people's view to a form of euthanasia and actually killing a person rather than a person taking their own life. So that's one concern that is apparent here. Then the doctor must remain with the patient until they die, unless, of course, the patient changes their mind, in which case, obviously, the drugs must be taken away. And then if the patient self-ingests and dies, then the doctor should complete a final statement. Now, one of the important concerns that has been raised, and I'll talk more about this afterwards in relation to my experiences with the citizens' juries, is that sometimes people don't die straight away and sometimes there are complications. So one concern is that, what would the doctor do if a patient, there was a problem, and for example, if the patient vomited up the medication and survived, what would be the most ethical response to that type of problem, and should the law need to state what ought to be done in that situation? And this is my final slide. So looking at the process, it's a lengthy, a fairly bureaucratic process that's envisaged under this law at the moment. It seems likely to take at least 6 to 8 weeks with the 2 reflection periods. And since only those who are expected to die within 6 months can start the process, it might be quite challenging to fit all this in. I mean, of course, the fact that somebody has a terminal illness expected to prove fatal in 6 months is in itself a tricky question, and lots of people have argued that actually it's impossible to predict death with any form of accuracy at that point in time. It's only when a person is much, much closer to the natural end of their life that it becomes feasible to say, oh yes, this person might die within a certain time frame. And we've probably all heard stories of people who were given a certain amount of time to live and they're still alive, 3 years later. And certainly that happens, but equally it's true that somebody who's given 6 months to live may die within a month. So how feasible is it to have an approach that seems to demand significant time and effort from a dying person? Is it, as Chris Whitty flagged in his committee evidence back in January, is it going to be a system that's mired in bureaucracy and therefore problematic? Or on the other hand, are the safeguards and the multiple assessments and the formalities required within the law, are these essential for a safe approach, which will enable only people who are really determined to take this route to go ahead with it? And I'll leave it there. Thank you.
Well, thank you again. That's going to raise some interesting issues about you need complicated and strong systems to make sure that any system is not abused. And as you say, we don't know how long many people will actually live when diagnosed with a terminal illness. But even before you got to that slide, it struck me that for many people, this is a process that will end with their natural death rather than any assisted dying. And I'd always had the imagination of assisted dying being relatively quick. And I can see why it should not be. But on the other hand, if you are in pain, why do you want to be, and you made the decision, why should you be forced in many ways to stretch this out for 8 weeks? Indeed, it may even encourage people simply to not bother with this route and then find another way of finishing their lives early. But that's something we can look at again later. But that is very interesting. So thank you again for that.